afternoon. Good afternoon. Welcome to the championship round of the 30th edition of the Stetson International Environmental Moot Court Competition. The competition began in 1996. It was a small affair then. There were only 12 teams, only one of which came from outside the United States, the University of Malaga in Spain. Since then, the competition has grown, and we have regional and national rounds all throughout the world. Indeed, this year, more than 150 teams competed on 5 continents. The international finals, which we host here in Florida, began on Thursday with 22 teams from 5 continents representing 12 jurisdictions. After introductory remarks from the Executive Secretary of the Convention for Biological Diversity, we started the oral rounds. There were 4 preliminary rounds. After those rounds, we then held the semifinals and we held quarterfinals and the semifinals, and we are now down to our 2 final teams. Representing the applicant is Team 58, Ateneo de Manila University School of Law. And representing the respondent is Team 54, West Visayas State University College of Law. We have an excellent final panel for you. Dr. Will Burns, who has been a final round judge for about 20 years. We have Professor David Wirth, who actually judged the championship round in 1997, and then also came back during the pandemic years. And we also have Professor Cristian Darani, who is from Brazil and an expert on the Nagoya Protocol. So best wishes to both teams. Good luck and have fun.
All rise. Court is now in order. The Honorable Judges Darani, Burns, and Wirth presiding. Judge Wirth will serve as president.
You may be seated. Before the International Court of Justice, the court hereby calls the case of questions related to the prior and informed consent and benefit sharing in the context of de-extinction. Anacoyan versus Ritas. Are both sides ready? All right, so we will hear first from the applicant, and so please begin your argument.
Mr. President, Your Excellencies, good day and may it please the Court. My name is Dorothy Tuazon, and together with my co-agent, John Matthew Tuazon, we respectfully enter our appearance as Team 58 on behalf of the applicant, the state of Anicoyon. For 14 minutes, I will be presenting applicant's first two submissions on prior informed consent. And thereafter, for another 14 minutes, my co-agent will be presenting applicant's last two submissions on benefit sharing. We respectfully reserve 2 minutes for rebuttals. Thank you, and may it please the court. Your Excellencies, in reviving the Royal Panther, the respondent risked far more than it sought to protect. Not only did it stretch the consent of the applicant beyond recognition, but their de-extinction project comes at a cost of the living species the Convention on Biological Diversity seeks to protect. Allow this agent to explain why in the applicant's first two submissions, which are first, that the respondent violated its treaty obligations when it failed to obtain the prior informed consent of applicant to de-extinction, and second, applicant's refusal to consent is well aligned with the objectives under the Convention on Biological Diversity. For the first submission, applicant makes two arguments. First, that de-extinction is not encompassed in the 2009 loan agreement, and second, that the respondent has an obligation to obtain the prior informed consent of the applicant upon their utilization of their genetic resource, Your Excellencies. Under the first argument, we point this court to paragraph 15 of the record for convenience, where we can see the terms of the 2009 loan agreement. The fossil was loaned to the National Museum of Ridas for purposes of educational and scientific research.
Is the loan agreement binding under international law?
Yes, Mr. President, it is binding as a form of treaty pursuant to the definition of a treaty in Article 21A of the Vienna Convention on the Law of Treaties. The parties have consented to be bound in paragraph 15 of the record, and thus we can use the Vienna Convention on the Law of Treaties, which leads me to my first point, where under the ordinary meaning of the terms, research does not encompass de-extinction. The ordinary meaning of research, as affirmed by the Nagoya Protocol commentary in the year 2020, is that it is fact-establishing activities, such as what did the Royal Panther look like.
So your position is that the research in the first place, the extraction of the DNA before we even get to the question of prior informed consent, was inconsistent with the loan agreement. Is that correct?
No, Mr. President, because we acknowledge that extraction of DNA could encompass research activities. However, de-extinction goes beyond DNA extraction and creating a product that well encompasses the term of development and not research. Allow me to make the distinction, Your Excellencies. Research refers to fact-finding activities such as what did the Royal Panther look like and what environment it lived in. Meanwhile, development is defined...
Agent, couldn't fact-finding encompass the rewilding project and then assessing what the viability of the species was subsequently, including offspring? Could that not be encompassed under fact-finding by your definition?
Your Excellency, assessing the environment and the ecosystem under the rewilding, yes, it could be under fact-finding. However, what the applicant is against falls under the term of development. Development is defined as a process to create a product. And the International Union on the Conservation of Nature Guiding Principles to Proxy Species in 2016 defines de-extinction as a process to create an organism that resembles an extinct species. And
But
here...
is this document based to be anchored to your argument? Is it an international document, international law document, the IUCN?
Yes, Your Excellency, the IUCN is in fact most highly qualified publicist pursuant to Article 38(1) of this court statute as a subsidiary means of interpreting a treaty for that matter. And under this document, it defined de-extinction as a process to create an organism that resembles an extinct species. And given that it creates a product, it falls within the term of development and not research. Therefore,
So you're making a distinction between research on the one hand and use on the other. What is your legal basis for that? What legal authority do you have for making that distinction? You said this is not research, but it is use.
we use the ordinary meaning pursuant to Article 31 of the Vienna Convention on the Law of Treaties. And as affirmed by Glauca in the 2020 Nagoya Protocol commentary, research is merely defined as fact-finding activities and development is defined as a process to create a product.
But again, Agent, fact-finding activities, right? That's exactly what this seems is being done here. It's to determine the viability of the species in terms of the process that's being utilized, and then potential viability of offspring in the wild, right? Which was the pronounced objectives. That seems to fall solidly within that core definition to me.
Your Excellencies, let us take a step back because we understand that development could include research. However, research does not include development because development goes a step further by creating a product for this matter.
But Agent, that's purely on the basis of an IUCN definition that's not legally binding upon this court, correct?
Yes, Your Excellency, it is persuasive upon this court.
Is the Nagoya commentary binding on this one?
No, Mr. President, we acknowledge that it is persuasive, but we may look into this court to interpret both the CBD and the Nagoya Protocol.
Why is it persuasive? Because it seems persuasive to me that fact-finding and the kind of thing that they're trying to do is salutary, right? And seems to be the pursuit of scientific research to me. Why is it persuasive to draw a distinction between scientific research and development in this way?
Your Excellency, may I clarify if you're asking about the sources under international law or
No,
the distinction?
I just want to know why you think it's persuasive.
It is persuasive, Your Excellencies, because we have to look into the policy behind the prior informed consent. Where, under the Nagoya Protocol commentary, benefit-sharing obligations are triggered. And for a country of origin to be informed as to their specific intended use, we must give the ordinary meaning of the term research and not conflate this to include de-extinction, which was outside of the realm of the 2009 loan agreement, Your Excellencies.
Go ahead.
You've several times referred to the Vienna Convention and the ordinary meaning test, so you're suggesting we look in a dictionary. Are there any precedents of this court that might be helpful in determining what is and what is not scientific research?
Yes, Your Excellency, we can look into the whaling in the Antarctic case decided by this court in 2014. In paragraph 71, it uses the ordinary meaning as well as in line of its purpose. And we can see the purpose of the 2009 loan agreement in clarifications 11 to the record, where the fossil was loaned to the National Museum of Ridas for a recently opened wing dedicated to the Panthera people. This means...
In this case, we will have also the statement that says that whether a program is for purpose of scientific research cannot depend simply on that state's perception. So who is in charge to say exactly what a scientific research is?
To guide us, Your Excellency, on who can say what scientific research is we look under a prior informed consent obligation. In their International Union on the Conservation of Nature Guide to the CBD, the user state has an obligation to inform the applicant or the country of origin as to the specific intended use. And nowhere in the 2009 loan agreement did respondent inform the applicant that it would be used for de-extinction. They only informed that it would be used under the Panthera wing under the National Museum of Ridas. Hence,
Precedents of this court and the Antarctic whaling case, how is that helpful to you? You have to remember that we are three legally trained experts and we are not scientists, so that we do not necessarily have personal experience of what is scientific research and what is not.
Your Excellency, we look into the whaling in the Antarctic case because it defines the term for purposes and for scientific research, which is similar to the 2009 loan agreement under this premise, Your Excellencies. And the purpose of the 2009 loan agreement was merely for the functions of a museum, as seen in clarifications 11 to the record. And
Agent, in 2009, did we contemplate this kind of process?
No, Your Excellency, although we acknowledge that the respondent may argue that de-extinction projects have existed in the year 2009, such as the Pyrenean ibex that was missing along and the passenger pigeon that died within minutes, this still could not be within the scope of the Convention on Biological Diversity. This leads me to my second submission, where applicant's consent is violative is applicant's refusal to consent, rather, Your Excellencies, apologies for that, is aligned with the objectives under the Convention on Biological Diversity. There was no way for a respondent's de-extinction project to even be encompassed under the Convention on Biological Diversity framework. Applicant fulfilled its obligation in Article 15.2 of the CBD, where consent is restricted to environmentally sound uses and aligned with the objectives under the CBD.
Agent, who determines that? Is it an objective standard? And why is it violated in this case from an objective perspective?
It is a subjective standard, Your Excellency. However, it is found in Article 15.5 of the CBD, which grants...
Subjective or an objective standard?
Apologies, Your Excellency. May I clarify if you're referring to who can decide or what is decided upon?
How do we determine reasonability and the standards?
We determine reasonability using the conservation objectives found in the CBD. We point this court to Article 8 that talks about in situ conservation. And in Article 8G, there is a prevention of alien species within the environment.
But made an environment impact assessment for that.
Yes, Your Excellency. However, in paragraph 174 of the pulp mills of the River of Uruguay case, environmental impact assessment is merely a pre-assessment and does not definitively conclude the results. And if we look under the precautionary principle, yes, Mr. President.
Mindful of the time, I suggest we move along to point B of your argument about whether whether Anacoyan's refusal to consent based on its objection to de-extinction is counter to the CBD's objections. And we're having some difficulty clarifying whether this is an objective or a subjective standard. But to what extent does this court have the capacity to overrule your refusal to consent? I mean, this is a sovereign act on the part of your state, and the respondent in its memorial and in its application have requested us to review that action. To what extent do we have the power to do that?
The court has the extent to do this if the state consents for this court to have jurisdiction over the case and decide on the matter at hand. Pursuant to SS Lotus, which is the case before this court, it decided that sovereignty may not be implied but rather expressed. And under this matter, given that the parties have submitted this...
Power, you say?
Yes, Your Excellency, you have the power to override.
Okay, and getting back to the question of my colleague to my right, what is the standard? Can you arbitrarily refuse to give consent?
The standard, Your Excellency, is found in Article 15.2 of the CBD, where it must be limited to environmentally sound uses and aligned with the objectives under the Convention.
The record indicates that Respondent conducted an environmental impact assessment and concluded that this comported with the principles of the CBD and protection of wildlife. Why should that not hold sway? Because you didn't conduct one of your own, presumably.
Your Excellency, it should hold because we note in paragraph 119 of the Pulp Mills case that when there is a transboundary aspect, such as the applicant that is being affected, they should seek the notification and participation of the applicant. And in clarifications 1 to the record, we can see that the applicant objected.
That's participation and input, but not necessarily veto over the decision of the state that's engaging in the project, correct?
Yes, Your Excellency.
So to the extent that Respondent has done an EIA, found that this comports with the principles CBD, should that not be dispositive?
Okay, please answer the question, and then that will conclude your argument.
Thank you, Mr. President. Your Excellency, we uphold the principle we do a balancing interest in terms of the principle of the sovereign discretion of a country of origin over their genetic resources. That is why, when balancing the interests of an EIA that is naturally done domestically, Respondent has an obligation to seek the participation of the applicant state, not only in the Pulp Mills case, but affirmed by Article 14 of the Convention on Biological Diversity, and the applicant refuses to consent to make sure that mankind activities do not lead to the destruction, but rather the cultivation and expansion of the environment. Thank you, Mr. President, Your Excellencies, and may it please the Court.
Will the bailiff please add on the time that was taken to respond to the question to the respondent's time? All right, now we will hear from applicant number 2.
Mr. President, Your Excellencies, good day and may it please the Court. My name is John Matthew Tuazon, Second Agent for the Applicant, the State of Anicoyon. Your Excellencies, this case is about profit without responsibility. It is manifestly unfair that the Sydney Animal Park reaps immense benefits, yet refuses to participate in benefit-sharing obligations. To establish this violation, allow this agent to raise two submissions. First, that digital sequence information, or DSI, constitutes as biotechnology, and second, that the Sydney Animal Park is a user engaged in commercialization of the DSI of the Royal Panther. Allow me to discuss them in turn. Under the third submission of the applicant, Your Excellencies, we submit that digital sequence information is biotechnology. Now, this determination is critical because it determines whether or not the obligation to share benefits arises on the part of the respondent. Your Excellencies, in simpler terms, DSI are digitized version of DNA. Take, for example, taking a photo of your certain animal and transforming that photo into information. This information, when analyzed, has the very characteristics of that genetic resource, meaning it has information as to its size.
What's the situation with reference to the definition?
Yes, Your Excellency. And this can be seen and confirmed, Your Excellencies, in Article 2 of the Convention on Biological Diversity on the definition of biotechnology, wherein it highlights three important elements.
But where in a legal document there is this connection between DSI and biotechnology definition?
This can be seen, Your Excellencies, in CBD Conference of Parties Decision 16/2. It is provided there, Your Excellencies, that the industry of genetic resources, even pharmaceuticals and agriculture, acknowledges that digital sequence information is part of their day-to-day business, as well as how to conduct scientific experimentation. Your Excellencies, allow me to indulge the Court on the second element of what biotechnology is, which the applicant recognizes to be the most contentious element, that the respondent may argue that DSI, or digital sequence information, cannot constitute as a derivative of a living organism because it is merely an information. Your Excellencies, the applicant respectfully rejects the standard. We look at the definition in ordinary meaning interpretation of the definition of derivatives, which is naturally occurring biochemical compounds.
Well, let's assume that DSI is a derivative, but it also has to be a derivative to make or modify products or processes for specific uses. Is this animal a product?
Yes, Your Excellency, it is the applicant's position that the royal panthers are a product or a living modified organism, given that there is a combination of two genetic resources. First is the genetic resource of the royal panther from the DSI, and second,
Wild cougar from which this was derived a product?
yes, Your Excellency,
A
given
wild animal is a product?
How are you defining product?
Your Excellency, a product according to the Cartagena Protocol provides that it is a novel combination of two genetic resources.
But a wild cougar is not a novel combination. A wild cougar exists in nature.
Yes, Your Excellency, to clarify, yes, the North American cougar is not a product. However, the royal panther, which was produced using the cells of the North American cougar, along with the blueprint of the digital sequence information of the royal panther, now, Your Excellencies, that would be the product and not the North American cougar. Your Excellencies, allow me to indulge this honorable court on the intent of the framers of the CBD. In the 1990 final working document of the Convention on Biological Diversity, they provide that they invite an open and flexible language to interpret the definition of biotechnology. In fact, in paragraph 70 of that final working document, the state of Brazil opened the discussion of including the word any at the start of the definition of biotechnology.
So you're referring to the vote preparatoire, you're referring to the negotiating history. To what extent is that binding on this court or even helpful?
Your Excellencies, this is binding before this honorable court because according to Article 31 of the Vienna Convention on the Law of Treaties, travaux preparatoires, or the preparatory works of different treaties, may be resulted into in order to unearth the intent of the framers to a specific treaty. And this confirms, Your Excellencies, that
In unusual cases, such as where the ordinary language is absurd or is unclear, biotechnology must have some meaning. I mean, the parties were using it. So I think that is something that this court, if you read its precedents, has generally discouraged the use and resort to travaux.
Certainly, Your Excellency, there is a regard as to Article 32 of the Vienna Convention on the Law of Treaties. However, the applicant submits that the evolutionary approach enshrined in Article 31 of the Vienna Convention on the Law of Treaties provides that there has to be an inclusion of contemporary developments in terms of scientific breakthroughs as well as scientific progress. Your Excellencies, science is constantly evolving. The applicant and the respondent cannot remain stagnant. To declare that digital sequence information is biotechnology, we take significant step into solving the challenging puzzle of preserving the world as we know it today. This leads me to the final submission of the applicant.
Move on. You referenced CBD decision 16/2. To what extent can we rely upon that as the law? To what extent is it binding?
Your Excellencies, this is binding in accordance with Article 38, Paragraph 1, Subparagraph D of this court statute, given that it is a work of a most highly qualified publicist, as established by the
Sorry, the CBD decision? It's the work of states.
Your Excellencies, to clarify, this can also be seen in Article 31, Paragraph 2 of the Vienna Convention on the Law of Treaties, which provides that these are subsequent agreements in relation to the treaty, Your Excellencies. And
Whether it's binding, I'm looking at the actual text of 16/2. Paragraph 2, all users should share benefits. Paragraph 3, users should contribute a proportion of their profits. Generally, the term should is understood as hortatory and non-binding. How do you get around that problem? How can we apply 16.2 as the law?
Your Excellency, I turn this honorable court to Article 15 of the Nagoya Protocol, wherein it provides for access and benefit sharing obligations, wherein states are obligated to share benefits whenever there is utilization of genetic resource or application.
But the text says should, that they are exhorted to, they are encouraged to. How do you get from exhorted to and encouraged to must?
Your Excellency, the applicant recognizes that the CBD COP decision 16.2 is voluntary in nature. However, we look at the provision on the Article 15 of the Nagoya Protocol by which the CBD COP decision is based from. Provided in their preamble, they recognize, Your Excellencies, that states have a role in terms of conservation, and this is to establish this multilateral mechanism designed to contribute to that conservation.
But Agent, if that's the goal, given the fact that unlike a product that Eli Lilly produces and then turns a portion of the profits over to shareholders, the money that's being derived from this, right, is ultimately ending up in further research, right? Isn't that just a fundamentally different way of doing this and comports with principles of conservation?
We respectfully disagree, Your Excellency. Conservation and sustainable development or commercialization of such is not a zero-sum game. In CBD COP Decision 16.2, it does not govern whether or not the benefits derived from such use inures to the benefit of the royal panthers or the species, but rather it governs the very activity that an entity undertakes. In this case, Your Excellency, the Sydney Animal Park is part and parcel of the de-extinction project. They form part of such project by housing the royal panthers up until their release. In fact, Your Excellencies, according to paragraph 34 of the record, they derive economic benefit by charging a premium to sell the experience of the...
Agent, what do they do with the funds that come from those charges?
In paragraph 35, it can be seen that the proceeds inures to the benefit of the royal panther and any excess goes back to the transboundary species provided in the Sydney Animal Park.
Right. So, again, isn't that a fundamentally different sort of thing than we see with development of a drug, where the funding flows to shareholders, right? Does this not quintessentially comport with the principles of CBD of trying to protect and improve the lot of wildlife species?
Your Excellency, we recognize this view. In fact, we applaud the respondent in terms of their attempt to conserve the royal panthers. However, Your Excellencies, we must take a step back as to the intent of CBD COP Decision 16.2. It is not merely for the benefits to arrive to the state of applicant, which is a low middle income country, but to be shared to different biodiversity-rich countries, as well as indigenous peoples who have within their possessions genetic...
Indigenous peoples. It's also on the record that the Pantera the people don't pay the entrance. So is that a kind of benefit sharing already?
No, Your Excellency, we recognize that the respondent does not charge anything for Pantera people to view the royal panthers. It may signal good faith on the part of the respondent. However, this does not remove the Sydney Animal Park from the fact that it is commercializing from those that are visiting the royal panther. Your Excellencies, in
How are you defining the term commercializing?
commercialization, Your Excellency, provided in the analytical work of DSI varies per sector. And in this case, the applicant submits that because the Sydney Animal Park is part of the animal and plant breeding sector, commercialization involves selling of merchandise, marketing, and regulation of such captive breeding program. And because of such, yes, Mr. President.
Sorry, I didn't mean to interrupt, but now it sounds oriented. We're now in part B of your argument. Is that correct? Does the fact that the zoo is a nonprofit make a difference?
No, Mr. President. In fact, in the paragraph 4 of the clarifications, the Sydney Animal Park is part of the regional campaign to captive breeding, analogous to the European Association of World Zoos and Aquariums. Most members in that association, Your Excellencies, are governed by non-profit organizations. However, most of them are considered commercial, solely because what we look at in CBD COP Decision 16.2 are not qualifications of these entities, but rather their activity by which they derive benefits from such use.
16-2, zoos do not appear in the sectors that may benefit directly or indirectly from the digital use. Does that make a difference to you? You're saying that this is binding, and your entire argument rests on that. But then you have to deal with the fact that zoos and nonprofit entities like them are not on the list.
Your Excellencies, we recognize that zoos are not part on the indicative list in Enclosure 1 of CBD COP Decision 16.2. However, the applicant submits that they form part 2 of those indicative list sectors, namely first, the biotechnology sector, and second, the animal and plant breeding sector.
That sounds like a bit of bootstrapping, right? They clearly knew about the existence of zoos and they expressly decided not to include them, right? Does that not seem like the most dispositive interpretation of whether they should be encompassed under this term?
We recognize this view, Your Excellencies, that the intent of CBD COP Decision 16.2 is to remove zoos from being a private entity, being obligated to share benefits. However, Your Excellencies, we always go back to the elements of CBD COP Decision 16.2. Yes, sir.
But you are part of the CITES Convention, and the CITES Convention explicitly says that the zoos are non-commercial activity.
Your Excellencies, the respondent may argue that in CITES Resolution 510, there is a zoological exception that exists. However, such is inapplicable, given that, Your Excellencies, there's a limitation that zoological exception only applies whenever a genetic resource is not displayed for economic or commercial benefit.
The problem that this is a zoo, or is the problem what the zoo is charging for and what it is in fact doing? Because we are a court, we understand that if we hold for you on this point, then that will change the landscape for zoos all around the world in an instant. Please do answer this question. And what exactly is this zoo doing that would cause it to fall effectively within the list that perhaps other zoos are not?
Mr. President, allow me to address the question in 2 layers. On the first layer, Mr. President, it is important to note that this does not open the floodgates for zoos to be obligated to share the benefits after they are introducing genetic resources to the people. We recognize that zoos are imbued with public interest. However, what the Sydney Animal Park is doing, apart from other zoos that commercializes genetic resources, is that they are deriving benefits from them and using that to drive their revenue.
Charge admission.
Your Excellencies, we recognize that the admission fees goes to the operational costs of zoos. However, in this case, there is a considerable excess. In fact, in paragraph 45, sales amounted to 130 million US dollars in just a year, and 4 million of such and 7 million of such came.
To eliminate the fee specifically to see the panther, you would be happy.
No, Your Excellencies. In fact, they are still obligated to share benefits as a non-monetary benefit.
Your time has expired. And
Thank-
bailiff, please do add the time at the end to the respondent's time. Thank you very
Mr.
much.
President, Your Excellencies. May it please the Court.
We will now hear from the respondent. Sir, you have the floor.
Mr. President, Your Excellencies, may it please this honorable court. I am Jose Emilio Luis Combatir, and I rise on behalf of REDUS as a first agent for respondent under Team 54. Together with me is my co-agent, Therese Herminanda. We are each respectfully requesting from this honorable court 15 minutes of your time for us to address our submissions. I will be covering our first submission, covering 2 issues, that on the prior informed consent requisite and that of the de-extinction project as an environmentally sound use mandate under the CBD. My co-agent will be addressing the second submission covering 2 issues, on the proper classification of the digital sequence information and the appropriateness of the benefit sharing obligations. Mr. President, Your Excellencies, allow me to preface this entire case with one fundamental question. Are fossils merely static museum pieces, or are they instruments with potential capable of fostering the future of biodiversity? The case of the applicant can be summarized into 2 key points. They claim that the state of REDUS has violated the prior informed consent requisite, and they also claim that the de-extinction project is not an environmentally sound use mandate under the CBD. In response to this, we give 3 key points, Your Excellencies. Number 1, the governing treaties are that of the 2009 Loan Agreement and the Convention on Biological Diversity, not the Nagoya Protocol. Number 2, prior informed consent was validly obtained because scientific research in 2009 already included DNA extraction and genome sequencing. And lastly, Your Excellencies, de-extinction is an environmentally sound use under the CBD.
Could you clarify why not the Nagoya Protocol?
Yes, Your Excellency. The Nagoya Protocol, if we look into Article 28 of the Vienna Convention on the Law of Treaties, specifically indicates the non-retroactivity application of treaties. It states the treaty provisions do not bind the party to any act or fact which took place prior to the entry into force. And in this case, Your Excellency, the Nagoya Protocol entered into force for these parties in accordance to paragraph 11 of the record in 2015. The 2009 Loan Agreement, according to
What is the
paragraph 15,
appropriate juncture for this court to focus on? Is it the moment of the extraction of the DNA, or is it the later step at which that DNA was used to create the digital sequencing?
Mr. President, we must focus on the 2009 Loan Agreement granting consent to the DNA extraction methods. Although it occurred in 2022, in accordance to paragraph 16 of the record, this was already granted consent by the state of Anicoyon, which...
Agent, this feels a little bit like gotcha, okay? In the sense that you say, well, look, you knew we might do this, right? Because it falls under scientific, right? But I'm somewhat sympathetic to the argument that this is far more interventionist than what people often consider scientific research. To the extent that now this party says, we don't want you to go that extra step, right? Why not acknowledge that and operationalize that as true prior informed consent?
Your Excellencies, we understand this court's concern. However, we look into the applicant's submission. They've clearly conceded that DNA extraction can be considered under the term scientific research. Therefore, this is not just an understanding from the state of REDUS. The state of Anicoyon and the state of REDUS had a meeting of the minds when it comes to the entering of the 2009 Loan Agreement. We read it as for purposes of education and scientific research for a 20-year period, and this was loaned.
Excuse me, coming back to the timeline. So you said about the 2009 agreement, but at this time, you were already part of the CBD since 1993.
Yes, Your Excellency.
And the CBD Article 15 already explicitly asked for the prior informed consent and giving also the details and how it must be accomplished. Why do you take only the Nagoya Protocol as the initial obligation of the prior informed consent?
Well, Your Excellency, since both are parties to the CBD under paragraph 10 of the record, then they have an understanding that the access to the genetic resources are bound and subject to the prior informed consent of the sovereign party granting access, in this case, the provider state, the state of Anicoyon. And with this understanding, in 2009, they were already aware of their obligations under the CBD, together with that of the state of Ridus. And this already satisfies the prior informed consent requisite, because by 2009, we already established the virtually uniform state practice of national museums acting as state organs for purposes of international law.
But Article 15 of the CBD states that the prior informed consent where granted shall be on mutually agreed terms. So it was not the case to be assumed that Anicoyon gave the prior informed consent to the extinction, but it should be so written in the prior informed consent.
Please allow me to clarify the case, Your Excellencies. The case of the prior informed consent is only to the extent of the DNA extraction and the genome sequencing. This was no longer understood to be required for that of the de-extinction project. This was only in our good faith application of how we would submit the environmentally impact assessment to inform the state of Anicoyon that we intend to use the digital sequence information for purposes of rewilding and de-extinction project.
The 2009 loan agreement in effect gave prior informed consent, is that correct?
Yes, Your Excellency, to the extent...
What is the matter with this way of thinking about the world, which is that the 2009 loan agreement was negotiated and concluded against the background of the prior existing law and therefore incorporated it all by reference, in which case there would be no need to specify the need for prior informed consent because both parties were already bound by the CBD.
Yes,
you obviously disagree with that interpretation, but why?
May I ask for clarification on that, on that case?
What I'm saying is that you say the 2009 loan agreement was in effect giving the consenting to the extraction. Another way of looking at it is that the need for prior informed consent was assumed by both parties and need not have been referenced in the 2009 loan agreement because there is already a contract valid on the international level as a treaty that provides for prior informed consent. There's no need for it in the 2009 loan agreement.
But that is the very essence of the 2009 loan agreement. It constitutes an express prior informed consent coming from the state of Anicoyon and together with that of the state of Ridus.
You need to help us understand why the actual agreement did that. It basically waived the requirement for prior informed consent at a later stage because they're saying it didn't.
Your Excellencies, let me clarify. They believe that we still require the prior informed consent for the de-extinction and rewilding project for conservation benefit. But the case here is that prior informed consent is not being contested to the extent of the DNA extraction and genome sequencing in the production of a digital sequence information. Does this clarify the case, Mr. President?
Yes, except that they withheld their prior informed consent.
Yes, Your Excellency.
So let's get to that part of your argument. I think you've helped us to hone in. I hope my colleagues this has helped us to hone in on what the issue actually is.
Yes, sir.
So prior informed consent was needed, but it was unreasonably withheld, which is the second part of your argument, as I understand it.
We disagree, Your Excellency and Mr. President. With regards to the access of the genetic resource found and embedded within that of the extinct royal panther fossil, this was clearly contemplated by both states of Anicoyon and Ridus. As we refer to the clarifications of the record, answer number 12, what is the degree of preservation or mineralization of the royal panther fossil, and it answers that it has sufficient DNA to construct a DNA sequence. In this case,
You mean that this loan agreement could be compared with a prior informed consent, as I understand. But when when riders take the sequence of DNA and send it to a private company, isn't it out of the purpose of the so-called prior informed consent?
let's clarify the timeline, Your Excellencies, Mr. President. The access to the genetic resource, specifically that of the royal panther fossil, was governed by the loan agreement and the CBD. And we have also fulfilled the benefit sharing obligations when we made the DSI publicly available in accordance to paragraph 28 of the record. This automatically fulfills all our obligations under the CBD and the loan agreement together with the state of Anicoyan. In accordance to the de-extinction project, which is another case that does not require the prior informed consent of the state of Anicoyan, but we still consider it, we sought it in good faith, but we recognize it that it is still not required in accordance to paragraph 23 of the record. We even engaged in negotiations with them. They disagreed with our conclusions. We also provided an environmental impact assessment to them and concluded it would have overall net positive benefits. But yet, they do not agree to these conclusions.
So you are requesting this court to render, basically to declare that the prior informed consent was unreasonably withheld.
No, Your Excellency, the prior informed
That's what the
consent
prayer for relief says, but anyway.
was already provided under the contract between the state of Anicoyan and the state of Fridas. In the
We hold differently from that. And please do address the second point in your argument and your prayer for relief about the unreasonableness of the withholding of the prior informed consent.
Yes, Mr. President. On the case of the refusal to facilitate access to the genetic resources for environmentally sound uses under the CBD Article 15, Paragraph 2, we must look into the very purpose of de-extinction in the first place. We looked into the very definition as provided by Dr. Beth Shapiro in her definitive work, How to Clone a Mammoth, The Science of De-Extinction. De-extinction is the high-fidelity reconstruction of a species' genomic blueprint found within the practical limits of genomic integrity.
Agent, who is this an objective or a subjective test in terms of the reasonableness of the withholding of the consent?
In the case, Your Excellency, with the withholding of the consent, this would be ultimately determined by that of the provider state in this case. But we still have to limit and ground that the DNA...
Well, in this case, Agent, clearly they don't buy your EIA, right? And they believe that there's a threat of invasive species in a transboundary context, right? And if you're saying that we should defer to their judgment and findings in this case, then they didn't reasonably withhold consent, did they?
Well, Your Excellencies, in this case, we are precisely undergoing ongoing mechanisms, rather, to ensure that we are fulfilling our mandate of the precautionary principle and due diligence.
But you said that at the end of the day, it's the folks that provided this fossil to determine if it's reasonable to withhold consent. And they said it's reasonable, we're afraid of invasive species. You may not agree with that, right? But you said that they get to make the decision. So to that extent, they did not unreasonably withhold consent, right?
Well, Mr. President, Your Excellencies, in this case, we did not utilize their genetic resource directly when it comes to the construction of the royal panthers, or rather the proxy royal panthers Ixchel and Samna. We utilized the digital sequence information we have crafted and created using the extracted DNA as merely a reference. The DSI was then made publicly available. It is not under the ownership of the state of Fridas.
But Agent, that's nice, but at the end of the day, if there's an invasive species, it won't be a digital apparition. It will be an actual invasive species, right?
Precisely, Your Excellency.
And the other party believes that that's a threat, and you've conceded that they should be able to make that decision. So they did not unreasonably withhold consent, correct?
Yes, Your Excellency, but in this case, is in regards to the reintroduction, rewilding, and de-extinction of the royal panthers to the state of Anicoyon, which is why we are putting mechanisms to keep them within the state of Redus. We place them under the care of the Sydney Animal Park in accordance to paragraph 33 of the record.
But agent, the other party still has concerns, and you said at the end of the day, their concerns should ultimately trump, right? So why, in this case, is it unreasonable for them to say don't do it?
Well, in this case, Your Excellency, the DSI was no longer under their authority. It is not a genetic resource that derived from the state of Anicoyon. We refer to the paragraph 28 of the record. When we extracted the DNA from the royal panther fossil, we utilized that as a reference to create a digital sequence information, and we utilized the North American cougar cells and the surrogate mother. We did not utilize any resource derived from the state of Anicoyon.
Okay, but it's,
Oh, go ahead.
but at the end of the day, the objective is the introduction of a new species in the environment. So it was said that an environment impact assessment was made, but in fact it's a case of an alien species, because it's a species that was extincted 6,000 years ago. And independent of the concern, which is a reasonable concern of Anicoyon, we have a statement at the CBD, Article 8H, that says that because of the conservation necessity of the ecosystems, the states should prevent the introduction of alien species. Wouldn't it be the case? So the introduction of this alien species in the environment?
Please answer the question, and then that will conclude your argument.
Thank you, Mr. President. In this case, we would have to contend and humbly disagree that this is not an alien species, Your Excellency. This is a creation of a functional equivalent to that original species, having the traits of both the royal panther and the North American cougar, capable of surviving within the current environmental conditions. Thus, in this case, Your Excellency, we urge this court to consider the binding bilateral agreement as a binding commitment between the state of Anicoyon and Redus to scientific progress. We do not seek to impose our will upon our neighbor. We invite them to stand with us. To this honorable court, may we preside not over the finality of extinction, but to have the courage to reverse it. Thank you, Mr. President, Your Excellencies.
Thank you. We will now hear from your co-agent, respondent, agent number 2.
Mr. President, Your Excellencies, may it please this honorable court. Once again, I'm Therese Herminanda, second agent, and I rise on behalf of the respondent of this case, the state of Redus. For the next 15 minutes, I'll be addressing our second submission, covering two primary issues. Is DSI biotechnology? And is Sydney Animal Park a user of DSI? Applicant submitted two main points to substantiate their claims. First, that DSI is biotechnology according to Article 2 of the CBD and the Nagoya Protocol. And second, that Sydney Animal Park is a user of that DSI. Respondent will be responding to these claims in the same order. And if this court has no preliminary questions, I shall now proceed. Thank you, Your Excellencies, and may it please this honorable court. Applicant is correct in providing the definition of biotechnology in accordance with Article 2 of the CBD and Article 2D of the Nagoya Protocol. It primarily provides for three main requirements: a technological application, the usage of either a biological system, a living organism, or derivatives thereof, and lastly, that it makes or modifies a product or a process for a specific use. However, Your Excellencies, to apply a concrete analogy as to how applicant submits how DSI fits in this very definition is like saying when a publisher publishes a cookbook, it is covered by policies and guidelines under the food industry, simply because they are publishing articles or pieces about food. However, this is governed entirely by a different matter. So it exactly contemplates that while DSI is one of the means and modes to be able to propagate biotechnology in that sense, it is not squarely applicable in this very sense. We note, Your Excellencies, that they highlighted on the third requirement that DSI is biotechnology because it created a product in the form of ixchel and examina. They equated the definition of living modified organisms to that of genetically modified organisms. And in that context, Your Excellencies, that is a complete misapprehension of how genetically modified organisms function. We note, Your Excellencies, that the existence of GMOs as of today already recognizes BT cotton, AccuAdvantage salmon, Atrine goats. The common qualities of these two products that are GMOs.
Yes. We've heard the definition from both sides, and obviously you disagree about the application of the plain meaning of the definition. Then the Vienna Convention on the Law of Treaties exhorts us to look to the objects and purposes of the agreement. Which of the two interpretations is more consistent with the objects and purposes of both the CBD and, let's assume for the purpose of this question, the Nagoya Protocol as well? We understand that you dispute that it applies to this case, but they are.
Precisely, Mr. President. We apply the position of respondent as more faithful to the definition of the CBD and the Nagoya Protocol. We understand that derivatives as well in that context under Article 2, subparagraph E of the Nagoya Protocol defines derivatives as a naturally occurring biochemical compound. So the flat reading of these definitions already contemplate tangible, physical, biological materials. It also contemplates that the application of CBD is geared towards physical.
The Panther itself biotechnology?
No, Your Excellencies. We humbly submit that it does not.
Derivative of biotechnology?
We also submit, Your President, that it is not a derivative of biotechnology. We note that it is a living organism, though. It is a product of the wonders of science in application of CRISPR technology.
Sounds like it satisfies the definition.
We humbly disagree still, Mr. President. On that sense, we note that CBD in the Nagoya Protocol contemplates physical, biological sciences. And while we understand that applicant has utilized evaluative interpretation in the sense, as also adopted by this very court in their decision, in the Gabchikovo-Nagimaris project's case, and also in the Pub Mills case, we note that this does not apply, given that judicial fiat cannot ultimately rewrite an already settled agreement. And silent in the CBD and the Nagoya Protocol is a definition that applies what digital sequence information is.
Let me propose a different view, which is that the CBD and the Nagoya Protocol intend to be a comprehensive and holistic response to the problem of biotechnology. And therefore, the terms ought to be interpreted broadly so as to include, among derivatives, a larger as opposed to smaller catchment area in case there is a doubt.
We understand that aspect as well, Mr. President. And given that there is an absence of that definition, both the CBD and the Nagoya Protocol, parties even turned recourse to CBD Decision 16/2, which still, to that effect, settled that there is no proper conclusion as to what digital sequence information still is. And then,
taking into account even the Vienna Treaty and also the Gabchikovo-Nagimaris, and added with the recent advisory opinion on the climate emergency, the agreements must be updated in the new state of technology. So I don't think that's also necessary to make an effort to bind DSI to biotechnology. And but I do think that we have to respect the development of the scientific discoveries, and also accept the decision 15/9 as well the 16/2 that contemplate into the CBD regime the DSI as such, and because of that the necessity of benefit sharing. Don't you think so?
yes, Your Excellencies, we take that into consideration as well, and we do not disregard that. We understand that science evolves along with time. And in that sense, still, silence of the CBD and the Nagoya Protocol to define DSI is a gaping loophole for us to include digital sequence information to be in the same context, in the same regard as
Agent, let me ask you kind of a broader philosophical question. You've gone through some incredibly fine distinctions about how we define biotechnology, and you've emphasized often that the science in this context and science more generally is evolutionary, right? Doesn't that argue against holding Applicant to a 2009 agreement that just broadly defines scientific research, right? Given the granular sort of evolution here, shouldn't you have had prior consent for these specific processes that you contemplate from a standpoint of fairness? And if you don't do that, isn't there a real danger that countries will stop providing these kind of resources to others for research?
We understand that concern, Your Excellencies. However, as my co-agent has already established, the prior informed consent has been encompassed by the 2009 loan agreement, spanning a 20-year period. The standard rate for agreements considering loaning of fossils and displays in museums are merely for 6 months to 2 years. However, this is already contemplating that science can evolve, technology can evolve, for the purposes of science, of education and scientific research, as found in paragraph 15 of the record. And in that sense, Your Excellencies, afterwards, the extraction of the DNA and the conduct of RIDAs for that matter to constitute a de-extinction project for conservation is a separate act that no longer covers or requires the prior informed consent of Anicoyon for that matter, which is exactly why, Your Excellencies, under paragraph 28 of the record, we freely provided the information of DSI to all people and uploaded into a public database because we recognize this information as open access for everyone, as information must not be impaired, which is precisely why adhering to applicant's submission that DSI covers biotechnology intentionally freezes that aspect, because digital sequence information is precisely that, information, separate from physical and tangible materials. If we adhere to that, Your Excellencies, it would effectively freeze biological sketches.
If DSI is not biotechnology, how then do you explain the existence of Decision 16/2?
Precisely, Mr. President, why judicial fiat cannot override the existence of the two treaties, CBD and the Nagoya Protocol. Recourse is...
If DSI were not biotechnology, why would the CBD take it up? How do you explain that?
We do understand, Your Excellencies, that there is growing knowledge with bioinformatics as to date, but that does not mean that there should be a delineation, or there shouldn't be a delineation between bioinformatics and biotechnology in that sense. And even in the intercessional period of CBD Decision 16/2, in the synthesis of views of the ad hoc tech expert group and the open-ended working group, viewed that there are state parties that actually do not consider digital sequence information as...
Forget that the Kunming-Montreal Global Biodiversity Framework in its Target 13 recognizes that the use of a digital sequencing information on genetic resource entails benefit sharing, representing a clear expansion of the original scope of CBD. So if it demands a benefit sharing, isn't it the case that the CBD adopted the DSI as a part of biotechnology and a part of its element to be considered as biotechnology, even after the CBD and the Nagoya Protocol, just because of this Target 13?
Well, we understand that view as well, Your Excellencies. However, we are disputing that DSI as an all-encompassing material or mode that should constitute biotechnology alone is absurd in the sense that as being adopted by applicant in this case. However, we do not dispute that it can be a means, a mode, or a tool utilized in a technological application, a biotechnology at that. However, the absurdity arises for applicant to raise that DSI alone, in and of itself, suffices as biotechnology, which is exactly why we cannot deem that Sydney Animal Park is a user of that DSI. Your Excellencies, applicant had already raised that we must look at a continuum, whether who made the research and development and who applied it later on, it's still one and the same thing, provided that we look at Sydney Animal Park's capacity to pay, and the mere fact that they have charged $40 in panther observation fees. However, that would be a misapprehension of the provisions of CBD Decision 16.
Agree with the applicant that 16.2, the CBD decision is legally applicable here?
This is persuasive, Your Excellencies. It also constitutes as a subsequent agreement of parties by virtue of Article 31.
Persuasive of what?
Sorry?
Persuasive of what? I mean, it has to be helpful in doing something. What is the something?
I stand corrected, Mr. President. This is in virtue of Article 31, Paragraph 3, Subparagraph A, which constitutes as a subsequent agreement of parties and is still encompasses as a part of a treaty under CBD in the Nagoya.
But it's not an agreement, it's just a decision.
We humbly disagree, Mr. President. It still squarely fits under Article 31, Paragraph 3, Subparagraph A. However, if this court is of a different view, then we submit that it squarely falls within Article 38, Paragraph 1, Subparagraph D, as a subsidiary means for this court to uphold.
Of the Vienna Convention.
Yes, of the Vienna Convention, and of the CBD as well, Mr. President. And in that sense, Your Excellencies, we cannot deem Sydney Animal Park as a user of DSI. There would be a dangerous precedent to set to mandate that Sydney Animal Park is in fact using DSI in this sense. We note that they have utilized the definition of utilization of genetic resources under Article 2E of the Nagoya Protocol. However, we highlight that it substantiates research and development as a primary component. And the record is silent that Sydney Animal Park dipped its toes in the research and development process.
Accepting that it's a research only, it doesn't excuse riders to pay some benefit, so to share benefits. If you take the CBD, Article 15, Paragraph 7, it said that each part shall take appropriate measure with the aim of sharing in a fair and equitable way the results of research and development and the benefits arising from commercial and other utilization of genetic resource. So not only the commercial utilization demands benefit sharing. So why don't share benefits with Anacoya?
We understand that part and your concern as well, Your Excellencies. However, we have actually consigned benefit sharing obligations, as with the actions of Sydney Animal Park. We note, Your Excellencies, that this must be harmonized by Article 12 of the CBD, Paragraph 1, and Nagoya Protocol's annexes, specifically in page 24, Paragraph 2, Subparagraph K. And so the housing of these panthers effectively showcases the ability of Sydney Animal Park to conserve and protect biodiversity, which they have already been doing since time immemorial. Paragraph 33 of the record would tell us that that is exactly why the state of Ridus consigned their help to house and care for these panthers, because they have already been engaging in captive breeding programs and have been taking care of 300 different species. Not only that, they also cater to transboundary species crossing to and from Anicoyan and Ridus. And contrary to Applicant,
Focusing specifically on the treatment of this animal, these two animals, and identifying that particular activity as commercial. Could you, so they're not criticizing the entire operation of the zoo, just this one particular piece of it. That, I think that was clear in their argument.
we note Applicant raised the application of CITES Resolution 5.10 that we may be tempted to use that. And we agree with their contention that zoos are primarily viewed as non-commercial. And precisely because there is an exception that if non-commercial activities do not clearly predominate, then they should be deemed as commercial in that sense. However, that specifically aligns to that exception, Your Excellencies. We see that there is no allocated benefits outside of taking care of animals or other social purpose activities in that sense.
But the Cali Fund demands a contribution. The decision 16/2, the Cali Fund says that only some institutions are not so entitled to contribute, which are the public, basically the public organizations, and the zoo is a private organization. Why don't to contribute to Cali Fund?
Please answer the question, and then that will conclude your argument.
Thank you, Mr. President. Precisely, Your Excellencies. On that end, this is exactly why zoos are generally viewed as non-commercial, yes, non-commercial in that sense. We note that this satisfies the specific requirement that under the indicative list of paragraph 37 in closure 1, the common denominator of the indicative sectors listed is purely commercial, purely engaged in profiting for nature. And that is exactly why zoos are not listed in the first place. And we note that applicant is correct that if zoos are to be taxed in this very sense, this would effectively discourage them from participating in conservation and protection of biodiversity ultimately, because it signals to us that what they're currently doing is not enough and that they still have to do more or they have to pay more. And that effectively stacks the obligations that already aligns with CBD and the Nagoya Protocol. Your Excellencies, thank you for your time and may it please this honorable court.
Thank you. We will now hear the rebuttal from the applicant.
Mr. President, Your Excellencies, once again, good day. The applicant raises 3 points for rebuttals. First, the respondent cannot claim, Your Excellencies, that the royal panther qualifies as an invasive species and escaping their obligation under Article 8, Paragraph H of the Convention on Biological Diversity. Your Excellencies, the Neolithic era, which is 6,000 years ago, is a different era as we have today. There are no saber-tooths, dodo birds, or even woolly mammoths that recognize the presence of these royal panthers. The environment we have today may not be the best fit for these royal panthers to be released in. In fact, they may constitute detrimental effects to the environment. Your Excellencies, under the second point, we claim that the respondent cannot take solace that they acted within the scope of the 2009 loan agreement. Your Excellencies correctly pointed out that Article 15, Paragraph 1 provides that there has to be mutually agreed terms by which states must act, and this has been gone beyond the contemplation of scientific research. Lastly, Your Excellencies, the respondent relied that digital sequence information must only take part as a tangible or physical output. However, Your Excellencies, the subsequent practice by which the states of China, Costa Rica, Australia, even Bolivia, have internal biodiversity law that extend derivatives to information, which provides that there's an established practice of such. Your Excellencies, across every discussion today, the respondent extends international law beyond sovereignty and to erode responsibility. This is not the law. This should not be the law that this court affirms. Thank you, and may it please the court.
Thank you to both sides. The court will take the case concerning questions relating to the prior informed consent and benefit sharing in the context of de-extinction on Anacoyan v. Reedus under advisement and render a judgment at the appropriate time. This court is hereby adjourned.
All rise. You may be seated.
All right, while the judges are deliberating, now comes the important part. The Easter eggs that are in the record. That all of the names and the dates have some significance. And so, wait, I can't, where's Kat? We have to have prizes to give out first. Ah. Yes. All right, we have many valuable prizes. We have T-shirts and coffee mugs and water bottles that you can choose from if you really know the record. Okay. All right. So we'll start with the names of the countries. What's the significance? Yes.
Yes, oh, it's the scientific name of diarrhea.
And yes, an anagram of the scientific name of the dire will. Very good. Come on. All right. Let's see. That's a difficult one. All right, we'll go with an easy one. What is the significance of the kingdom of Mammothus? Yes.
It's the scientific name for the woolly mammoth.
Yes, woolly mammoth. Yes. Please go. All right, slightly more difficult. The Minister of Foreign Affairs for Anakoyan.
Oh, no.
Ah, yes.
Is it the black rhinoceros?
No. No. The Minister for Foreign Affairs for Anakoyan is Serena Tangmite. Serena Tangmite.
Which one?
Yes, Professor.
What's that? A hint. A hint. It's an anagram of an extinct species.
Oh, Dryos, the species name is Dryos, I believe? Not Virus?
No, this is a more common name. So it's not the scientific name.
Is it a saber-tooth tiger?
You're close, but not that. Found in the, yes? The Tasmanian tiger, absolutely. Come on up. All right, if you had trouble with that one, this one should be a little bit more difficult. But it's all right. All right, so the Minister of Foreign Affairs for Ridus, or Redus, how was that pronounced? Is Nexia brapine. What is that an anagram of? Which extinct species? It was supposedly de-extincted through cloning.
The Pyrenean ibex.
Oh, the Pyrenean ibex. Yes. Go ahead. All right. Let's see. Oh, the special agreement was signed in Cincinnati, Ohio, in the United States. What's the significance of Cincinnati, Ohio, to extinct species? Yes.
I believe there is a zoological there in which the passenger pigeon was extinct or something like that.
Yes, it was the last, Martha, the last passenger pigeon. Yes. Let's see. All right. So, as you know, the royal panther went extinct approximately 6,000 years ago, likely due to overhunting by the Blythe people. What is the secret?
The Panther blighty, an extinct caniform.
Yes, yes, the oldest big cat fossil found in Tibet. Come on up. All right. right, we have an ambassador's name here. DB Longpipe. Long Yes.
It stands for the Diceros Viconis long pipes, the extinct western black rhino.
Exactly, yes. Extinct subspecies of the western black rhino. Yes. All right. So what happens when we do this? We come up with the names, they all have some significance, and then I forget to write it down. And then the day before we try to say, okay, what does that mean? And we don't know what this one means. And it may be a misspelling, I don't know. But we will accept the most logical response for the ambassador L. Vexifer. Yeah, oh, you know. Please tell me, because it's been haunting me.
Vexillifer, the Yangtze River dolphin.
Yes! Excellent one! Yes! The whole team can come up. Everybody, the whole team comes up for that. Yes! Ah! We try. No, the whole team. Oh, thank you. It's been haunting us. We tried to... We put it in the chat GPT and we tried it for that. We're like, what, we said, oh, the Stetson International Environmental Moot Court record is known for its Easter eggs. What's the significance of this? And it didn't help. Excellent. All right. Okay, all right. An easy one. The Salos company is, yes? Colossal, yes. Come on. Also an easy one, the Sydney Animal Park. Oh, and you've already gone, yeah. Yes, the Disney Animal Park, yes. How much does it cost to get into the Disney Animal Park?
$119.
Yes, $119. Come on up. All right. The names of the Royal Panthers or Royal Panther proxies, depending on your point of view. Ixchel and Isamna. Yes. Come on up. You're next. All right, you had to. Go ahead. Yeah. All right. Okay, what's the significance of the aid to the rightist minister, Dr. T'Challa? Yes.
Black Panther.
Yes, from the movie, character from the movie Black Panther. Yes. Had that one. Okay, all right. Let's see. What? Okay, so a number of the dates are significant as well. We'll start out with the easy one, April 22nd.
It's Earth Day?
Yes, it's a UN Mother Earth Day. Yes. Yeah, so do you already have one? So one of your team. Go ahead. All right, what about, let's see. This one's a little tricky. December 19th. December 19th. Okay, we'll come back to that. Oh, yes?
Splashdown of Apollo 17.
What's that?
Splashdown of Apollo 17.
It may have been, but... okay, all right, let's go with, let's see, August 13th.
Is it International Wolf Day?
International Wolf Day, yes, come on now. September 16th. That is actually correct, but not what we're looking for. But correct. But you get one anyway. That's good. That's really good. Yeah. World what? Ozone Day. Yeah, that's same one. Yeah, World Ozone Day. It also. Let's see. Might be. Let's try. Okay. Well, how about November 9th?
World Day of the Environment, right?
I don't think that's it.
Is it Biologics Day?
Is it the...
How about September 27th? World Tourism Day. Yes, come on. Yes, come on up. All right, hold on just a second. Let me check here.
It's all up to you, Honorable Court. Sure. One more. 7 members of the, all 19 members of the ICC.
All right, one more question. One more question. Who is the Royal Panther named after? Oh yeah. Okay. All right. Okay.
Box for everybody. Yeah.
I think we're going to have the judges come out.
You may be seated. The court is no longer in session. And we are back here as the bench to first of all thank you all for coming, thank you all for participating, to congratulate you on getting to the final round, and to congratulate all of the participants. Maybe the first thing to do is to introduce ourselves. Is that all right? So I'm David Worth. This is not my day job. I'm from Boston College Law School, actually Professor Gardner's alma mater. We're very, very proud of him. And I'm a professor at Boston College Law School. I specialize in international environmental law. I started out at the State Department actually negotiating agreements, not these, but agreements like them, and then I worked for quite a long time in nonprofits at the Natural Resources Defense Council. So, and this is actually my third time participating in the Stetson Moot Court. So I'll turn to my left and my colleague.
So I am Cristiane Berani. As you saw, English is not my mother language. I am from Brazil, and I am a professor of Federal University of Santa Catarina, and I am a professor on international environment and economic law. I used to be an attorney also that worked on biodiversity issues, so I like very much to be here. It's my first time at Stetson, and I really appreciate. And also I am working now for the Global Alliance Against Hunger and Poverty as an academic representative. So it's really my pleasure to be here among you, and I hope we can do that more times.
Great. So I'm Will Burns, and I am the director of the Institute for Responsible Carbon Removal at American University. My PhD is in international environmental law, but most of what I do now is more on the science side. Used to live in this world more. I was the founding editor-in-chief of the Journal of International Wildlife Law and Policy, and the founder of the International Wildlife Law Conference that preceded this meeting, and have spent a long time in the NGO sector working on wildlife issues, primarily whaling issues, and then now focus primarily on climate change and legal aspects of governing geoengineering.
So I think it's the custom now for us to give you some feedback from this round, and why don't I start? First of all of you were very impressive. I understand this is the third time you have argued today, is that correct? So you must be tired. You're entitled to a little relief and a reception afterwards. I think it's fair to say that all three of us on the bench were very much impressed with all of you. We hope that you continue to work in this field, which is one that has a bright future going forward. You can see that there are many legal issues still waiting to be explored, including the one in this particular problem. So we thought that the level of familiarity with the law and the record was very impressive. All of you were capable of referencing the record without consulting your notes. There was no paper flipping, or I was flipping papers, but you weren't. And that's very impressive. At my school, I'm actually the faculty advisor for the Jessup International Moot Court Forum, which this is modeled, and all of our students are trained to argue without notes. And so you all came across very effectively that way. Good work with the facts and the law, and an ability to respond to the judge's interventions. The judge's questions are, I know it doesn't look this way when you're standing up there as a lectern, but the judge's questions are your friends. They are indicated, there's a reason why judges ask questions, which is not just to harass you. It is to, that they are interested in, you have asked us to perform a particular task and to produce 4 responses in response to the prayer for relief on the part of the applicant and the response by the respondent. So we are aiming towards those responses. I hope you could see how the questions were targeted to get there. So the questions are not random, and also they also require you to interrupt your argument, but then come back and to keep it in mind while you're answering the question. Sometimes you have to come back to the argument. Sometimes you can move ahead. The bench also gave you some cues about when it was time to move forward. All of you took them very well, because you don't want to argue with the judge about where the argument is standing. So as I think is to be expected when you get to the very, very last round, the championship round, the quality of the performance is very, very high, and you should all be very proud of your accomplishments. And I hope you take this experience back with you to your home institutions and your home countries and put it to good use. So over to my colleague, my Brazilian colleague.
So after saying that I agree with you, I would just say that you are all a winner, because to have such a work and to be here and to be interrupted all the time and have to rephrase all your thoughts in the moment, it's not easy at all. So you have here accomplished a very difficult text, and you are very superior to any other students that doesn't do that. So you are already a winner to have this courage. And the only thing I want to say is wish you luck and to keep your courage to move you forward, and to believe in your ideas and in your strength to, specifically in this topic, environmental issues. We need this new generation to make our world a better world. So that's the thing I would like to say. Thank you very much.
Professor Brew.
Right. It's always easy to be last, right? So I concur with everything that was said before this. You're clearly both credits to your institutions and to your respective countries, and they'll be lucky to have you in the field if that's where you go or whatever you pursue. So it's. I think it's a fantastic experience. It's just one of the best ways to train to be a lawyer, right? And to do it at this level is going to provide, I think, a really, really fulfilling journey for you. The one thing that I would say in general about thinking about these issues is always reading the bench and figuring out what the role of different judges may be and the different ways they look at things. What I try to do, I've judged this thing 20 times, okay? And what I try to do these days is get a sense for who I'm judging with. And I was judging with two people that were going to look at a lot of the specific provisions of the treaties, right? So I decided I was going to do the policy side more, right? And so if you get a question about why something is persuasive, right, you really have got to think about from a policy perspective, right? At the end of the day, how will this comport more with the provisions of the treaty? How will it comport more with our overarching sort of objectives, right? As opposed to another construct, right? And that means less looking at the specific terms and more broadly trying to define what is policy optimal, right? And something is only persuasive, right, if it comports with those notions, right? So I thought both teams should always be thinking about that, right? If you're going to say it's persuasive, you better know in advance why you think it's a good argument, right? Just because some jurist says it, just because some law professor says it, right? It's not persuasive per se, right? So always think about that, because you will get, almost through your entire career, invariably, you will get judges of that nature also, right? So you have to be prepared to give them what they need. But fantastic job, safe travels back, and thank you very much.
So the bench thanks all of you, and the president returns the proceedings to the host institution and Professor Gardner, and many thanks to Stetson and to him.
Thank let's give our So the Royal Panther is making a fleeting appearance right now. We're going to do the award ceremony, and then after the award ceremony, you may have your picture taken with the judges, or you can have your picture taken with the royal panda.
Mere judges or royalty take your pick.
But are we invasive?
Judges, may I get one photo of you guys? Thank you.
Well, I'm going to turn it around right now. Let's see. Here, let's just put it here. Center. And let's see. In terms of taking, let's move. All right, let me start with some initial thanks. Many thanks to the Secretariat of the Convention on Biological Diversity for providing us the welcome video to start these rounds. Also, thank you to our sponsors, especially the Environmental and Land Use Law section of the Florida Bar, and Patricia Toops, a staff member who works here at Stetson, who just loves this competition. We thank them very much. We couldn't do this without our regional and national coordinators, and we have a couple in the room. I thank them all, but thanks to T.P. Kennedy and to Dr. Sammy. For the international finals, we had more than 100 oral round and memorial judges. Thank you. Need to thank the Stetson faculty, Stetson administration, but especially the Stetson student volunteers. That's what makes Stetson a special place. In addition, I'd like to thank Janice Strawn and everybody in faculty support, all the folks in facilities who helped set these things up, and our fine media services team. All right, I'd like to proceed now to recognizing each of the teams. Come up and have a certificate. I'm trying to think about whether, in terms of photographs, whether we should.
Luke will stay back a little bit.
Yeah, I'm just trying to. I can't remember if this is. We probably should try to move it. Let's see. Okay, so we'll start with. Maybe I'll just jump over here and we do it. Team 14, Lloyd Law College, India. That work for the background? All right. Team 16, Singapore Management University, Yang Pong Hao School of Law.
Sorry, that's thank you.
Thank you.
Team 21, Peking University School of Transnational Law. Team 25, Singapore Management University. Team 32, Mackenzie Presbyterian University, Brazil. Team 35, Sungshil University, Republic of Korea. Team 40, Nalsar, India. National Law School of India University. Bengaluru. Oh, they're not here? Okay. All right. Habe Rihanna University, Columbia. Cuidado. Team 48, Law Society of Ireland. Team 50, Howard University School of Law, United States. Team 51, Southwestern University of Finance and Economics, China. Team 54, West Visayas State University College of Law. Team 55, School of Law, Christ, deemed to be University, India. Team 58, Ateneo de Manila University School of Law. Team 65, Federal University of Bahia, Brazil. Yes, and please, we opened up, with the cultural showcase on Wednesday night, and the first person to get up to sing a cappella was Team 70, Lahore University of Management Sciences, Pakistan. So I know you all had to travel very far to get here, and there were many challenges, but that particular team, I believe, had 40 hours of travel, arriving at 2 a.m. in the morning the day they had to argue. So, thank you. Team 73, University of Chicago, United States. Team 75, Africa Nazarene University, Kenya. Team 77, University of Dhaka, Bangladesh. This team actually probably, I think, holds the record for having most clarifications answered. They asked 5, and 4 of them were answered. But yet they came up to me and said, why was the 5th not answered? 4 out of 5 is tremendous, so thank you. Team 83, China University of Political Science and Law. University of the Philippines. We'll now move to the top oralists in the preliminary rounds. It was very close, and so we're actually going to announce the top 10. The 10th best oralist was Rezon Asraf from Team 77, University of Dhaka. Ninth best, John Patrick Silvavan Palquin, Team 54, West Society. Number 8, Catherine Berry, Team 73, University of Chicago. Davis Turner, number 7, Team 73, University of Chicago. We should have done them together. Sixth best oralist in the preliminary rounds, Charlene Mangubat Lastrolo, Team 86, University of the Philippines. The fifth best oralist, Jiansu Peng, Team 21, Peking University School of Transnational Law. Number 4, Aaron Real Angshan, Team 86, University of the Philippines. The third best oralist in the preliminary rounds, Therese Diane Nava Dilanda. The second best oralist was Philly Dia from Team 75, Africa Nazarene University. And the top oralist in the preliminary rounds was John Matthew. Team 58, Applicant de Manila. All right, moving on to the memorials. The memorials, again, actually the scores were quite close. The number 3 memorial, Team 35, Sung Shil University. The runner-up Best Memorial, Team 40, Nalsar, India. In the early days, we actually used to give very large globes as an award, but then a team from India won, and they were like, "Can you ship it back?" We can't take it." And the award for the best memorial goes to Team 46, Javeriana University. So the Spirit of Stetson Award, which was voted on by you, goes to Team 32, Mackenzie. Okay. All right. We'd like to recognize the quarterfinalists. We'll start with Team 14, Lloyd Law College, India. So for some of your certificates, if you don't have 3 signatures on it, don't worry. We'll come up afterwards. We'll finish signing them. the the Royal Panther has some trouble signing. Team 25, Singapore Management University. Team 35, Sung Shil University. And Team 86, University of the Philippines. We'd like to recognize our semifinalists, beginning with Team 16, Singapore Management University, Yong Kong Howe School of Law. And our other semifinalist was Team 21, Peking University, School of Transnational Law, China. So the runner-up for this year is the Respondent, Team 54, West Visayas State University. And the champions of the 30th Stetson International Environmental Moot Court Competition is Team 58, Ateneo de Manila, University School of Law.
flag, bawal mag-touch.
Who's that? Oh, that's great. And the best oralist in the championship round goes to Therese Diane Nava and Team 54, West Society. So some final thank yous. I mean, first of all, I have to thank the folks that I work with, the team, the competition committee. We could not, it's nice. I walk around, people say nice things to me, they compliment me, but really, the people who really stress about this and work on the details, you know who they are. Catherine Pratt and and finally, I'd like to thank all of you, the competitors and coaches. In the age of generative AI, Moot Court stands alone because you stand alone at the podium. You can't rely on pulling something up from your computer. So thank you for your hard work, your creative arguments, and your unflagging energy. And as you proceed with your studies and your career, you'll use the advocacy skills that you have developed and honed through this process. But I also urge you to use the specialized knowledge that you've also gained through this Moot Court. Just don't let it sit. Write an article about it, or Professor Zarani and I will be in touch. She is the chair of the Ethics Specialist Group of the IUCN World Commission on Environmental Law, and she would like to expand this discussion within that forum to continue the dialogue and engage a broader range of stakeholders. And so you will be invited to that. So, and then finally, stay in contact with your new friends and colleagues. You're now part of the Stetson International Environmental Moot Court community, mentor and coach teams, judge in the national and regional rounds, and you are always welcome to come back and join us at the international finals. Thank you, and safe travels. And now it's time to release the Royal Panther.